Eric St. Ange.
This is case number 26-87FY, the people of the state of Michigan versus Eric Joseph St. Ange Jr. Sir, did you have the opportunity to meet with somebody from the defender's office today?
Yes.
I have a form that was completed by Community Corrections, and it looks like you gave them some contact information. Was that information accurate?
I believe so, yes.
An address on Hillcrest?
Yes, sir.
Phone number ending in 9254?
Yes, sir.
I have a complaint that alleges that on or about September 19th, 2025, in the city of Cadillac of Wexford County, it's alleged in count number 1 that you committed the offense of assault with intent to do great bodily harm less than murder or by strangulation. That is a felony punishable by up to 10 years in prison and or a fine of $5,000 in DNA to be taken upon arrest. In count number 2, it's alleged that you committed the offense of domestic violence aggravated. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000. Do you understand those charges and the potential penalties?
I do, sir.
Sir, we have conflicting birth dates for you. Is your birth date the 29th or the 23rd?
So it's the 23rd. My license, I've been trying to go to Secretary of State to get it fixed, but my license says it's the 29th.
All right. On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Could I request the appointment of an attorney, please?
All right, court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Do you understand that?
I believe so, sir, yes.
So within 21 days, there'll be a hearing in which the prosecutor will present evidence. I'll make a determination if there's probable cause that the crimes had occurred. If not, the case is dismissed. But if I do find probable cause, you'll be ordered to stand trial in circuit court. Does that make sense?
Yes, sir. Yes, sir.
All right. Prior to that hearing, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there is a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, in 15, I show an aggravated assault, 17, operating without security, in 17, a failure to transfer title and operating an unregistered vehicle. In 13, no license. And in 14, a jostling. The praxis scores him at a risk level 2. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. I'd ask the court to factor in that he does have strong ties to the community. He informs me he's been working at the local Burger King, or one of the local Burger Kings anyways. The past 2 years, he's been staying at the address he gave for the last 10. I do believe he has more in the courtroom behind me. If I recall correctly, his mother and his sister, they do want to see him back home. When I met with him earlier, I advised him that with these type of allegations, there's almost always no contact orders. He advised me he'd be able to obey that and any other non-monetary bond conditions the court wanted to place on him. No threatening or intimidating behavior or things of that nature. However, with jobs such as Burger King, even though he puts in good hours, and it's definitely something that he's probably seen me in the drive-thru, to be frank. But he doesn't have significant savings, Your Honor. So I'd ask the court to set the bond as low as possible. With these type of allegations, we realize that personal recognizance might be asking a lot. But we'd ask the court to keep it as low as possible and preferably at a 10% so that he could have his friends and family pool resources together if possible. Thank you.
Ms. Lawrence, on behalf of the people.
Your Honor, the allegations in this case are that the defendant was arguing with the victim. He had slammed her into a wall, was throwing her around the room, and also was choking her. I will say I did briefly look at the photos. And the victim did have pretty serious bruising and marks around her neck. Just so the court is aware, the victim does not want a no contact order. I would still request the court to impose one. These are very serious allegations. The people do have a concern for the victim's safety, so I would ask the court to do a no contact order. I also think, given the seriousness of the charges, this is a 10-year felony, I would ask for some sort of monetary bond to be imposed. I'll leave that to the discretion of the court. Thank you.
Thank you, Ms. Lawrence. I noticed that the charges are from September. When did your office receive the request from law enforcement?
It looks like we received this report on September 23rd.
Mr. Carnes authorized it June 6th. All right, the defendant does have an assaultive history. However, it is over 10 years old. This is alleged to have taken place back in September. I do find the defendant is a threat. However, I believe we can handle that with some bond conditions. Sir, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Is there any allegation of drug or alcohol use?
It's alleged that they did have a few drinks at a bar before this occurred. There's not necessarily proof that he was overly intoxicated. Law enforcement did not have contact with him that night.
Okay. Also, I'm going to order that you not have any contact with Brianna, excuse me, Nicola. You are not to purchase or possess any firearms or weapons, not act in any threatening, intimidating, or harassing behavior. No alcohol with random testing, no illegal controlled substances, including recreational marijuana, and random testing. Bond will be set at $5,000 cash surety. Next arraignment. Person at the jail, please state your name for the record.
Michael Davis Haynes, Your Honor.
Mr. Haynes, I have two files for you. The first is file number 26-184FY. In that file, I have an amended complaint. But first, let me ask you, you met with somebody from Community Corrections and gave them some contact information, and I realize it's a mailing address up in Fife Lake. Is that still a good mailing address for you?
Yes, Your Honor, and if you recall, on my old case, I left town. I'm at downstate in Grand Rapids at 4540. I'll stay in there and up until yesterday, I was on my way to do what I told you I was on my way to do. I was going to rehab. It was set up for today at 9 o'clock at Harbor Hall. I couldn't find no ride. I found a ride, and this ride ended me up in here, Your Honor.
All right. Telephone number ending in 8382, still a good telephone number?
Yep.
Did you have the opportunity to meet with somebody from the defender's office today?
Yep.
In this file, I have a complaint. Actually, it's an amended complaint that states that on or about January 11th, 2026 in the village of Manton in Wexford County, it's alleged in count number 1 that you committed the offense of assault with a dangerous weapon or felonious assault, in particular a handgun, That is a felony punishable by up to 4 years in prison and or a fine of $2,000 with DNA to be taken upon arrest. In count number 2, it's alleged that you committed the offense of firearms possession by a felon. That is a felony punishable by up to 5 years in prison and or a fine of $5,000 along with mandatory forfeiture of the weapon or device. Additionally, the prosecution has opted to charge you as a habitual fourth offender, meaning that you have at least 3 either attempted or completed felonies in your past. That makes that 4-year felony in count number 1 a 15-year felony, and in count number 2, the possession by a felon, a life offense. Do you understand those charges and the potential penalties?
Yes, Your Honor.
I don't want you to say anything, Mr. Haynes, I don't want you to say anything about the charges yet. All right. On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I shouldn't be here, Your Honor. They owned up to all that.
Mr. Haynes, my question is today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I have no money. I'm trying to better myself. I have no money. No. Your Honor.
Your Honor, if I may.
I can't afford one.
Mr. Haynes, you want the court to appoint an attorney?
Yes, Your Honor.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Before we get to bond on that case, in file number 25-3779 SM, I have a warrant for a probation violation. This is the telecommunications malicious use file.
Oh, what?
It's alleged. This is the file that you're on probation for the malicious use of a telecommunications device. In this file, it's alleged that you're in violation of your probation for new criminal behavior, in particular, assault with a dangerous weapon, felony, or possession of a firearm by a felon, habitual fourth offense as reported by the Wexford County Sheriff's Department. That is a non-technical violation. If you are found in violation of that probation, you could be sentenced to what you could have been sentenced to under the plea, which is a 6-month misdemeanor. Ms. Bismack, that was a completed offense, not an attempt, correct?
Correct, Your Honor.
Yes. All right. So up to the 6 months. In that file, you do have the right to have a contested hearing in which the prosecution would have to prove to the court that you were in fact in violation of your probation. You also have the right to have an attorney appointed in that case as well. So my question to you, first of all, are you requesting the appointment of an attorney in the probation violation file?
Yes. I don't know.
All right, so we will,
Yes.
yeah, you're on, yes, yep.
And I was. I received November 26th.
Okay, Mr. Haynes, you are not a stranger to this process. So let me finish what I need to do and then I'll give you some time, all right? So we will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea to the probation violation, and we will set the matter for a contested hearing. Now, that gets us back to bond in both of these files. Historically, counsel, I show in 96 a larceny in a building as a juvenile, 99 malicious destruction of property less than 200, 01 a home invasion second, 04 an attempted carrying a concealed weapon, 05 malicious destruction of property less than 200, 07 retail fraud third, 07 B&E of a vehicle with damage. 07, driving the license suspended. 08, uttering and publishing. 09, driving the license suspended. In 10, distribution of imitation controlled substances. In 12, malicious destruction of property less than 200. In 13, a domestic violence. 14, a domestic violence second. 16, a domestic violence. 18, malicious destruction of property 200 to 1,000. 19, larceny less than 200. 20, a felonious assault. 19, a domestic third. 19, receiving concealing 1,000 to 20,000. 24, use of methamphetamine. 25, retail fraud third. 25, malicious use of a telecommunications device, which is what he's on probation for. In 18, there was an unlawful plate on his local record, not showing on his CCH. In 2000, there's a driving license suspended second. 07, a no license. 19, a domestic violence. He's currently on probation in one file, as we discussed. He's on bond in 2 other files for us, one being a delivery case and the other being possession of ammunition, possession of body armor, all as a 4th offense. As conditions of bond, which he has bond violations pending in those, and as conditions of bond in those files, or at least one of them, he was not to purchase or possess any firearms or weapons or act in any threatening, intimidating, or harassing behavior. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor, especially knowing that I'm not the attorney in all those files. The other attorney, I believe, is Mr. Champion, who's in trial in Suffolk County, just of course aware. What I would ask the court to do is set everything for a contested hearing. And if he could be released to treatment, directly to treatment as a bond condition. I won't go into too much about things protected by the attorney-client privilege. But what I will say is I do believe he'd benefit from it. I know my office social worker, Mr. Brian Henniger, would always help as much as he can. He may still be in the courtroom here today. But I believe there are ways that he can be sent directly to treatment so that whatever variables may or may not have been at play would no longer be at play. I ask the court to consider that. Thank you.
Mr. Haynes is represented by Mr. Tylinda, not Mr. Champion.
I apologize for my misunderstanding, Your Honor.
And I failed to note that the praxis scores him at a risk level 8. Any comment regarding bond, Ms. Lawrence?
Thank you, Your Honor. At this point, I think we're a little bit past release to treatment. Even just the number of open files Mr. Haynes has clearly shows this is an issue. And he is not doing well on bond. He's not doing well on probation. So in the meantime, I would ask for a remand in his probation violation file. In his new file, I will note I do not have a police report at this moment. It's my understanding the defendant pointed a gun out of the vehicle at the victim. In that file, I would ask for a no contact order with the victim, being no weapons and firearms provision. And I would also ask the court to set at least $150,000 bond. The fact that he is on bond for similar charges involving weapons, I think a monetary bond is appropriate.
I'll also note that the probable cause affidavit filed in the new case indicates that at the time of the stop, a handgun was found in Mr. Haynes' possession. The court does find that Mr. Haynes presents as a threat to the community. As such, bond will be set at $500,000 cash surety. I believe that's appropriate given that his past convictions, the fact that he's on bond in 2 other cases, the fact that one of his bond conditions was that he was not to act any threatening, intimidating, and harassing behavior. This is alleged to have happened while he was on bond. And as another bond condition, he was not to possess or purchase any firearms or weapons. And as a convicted felon, he was not to purchase or possess any firearms or weapons. As such, I believe the monetary bond is appropriate in that case, with the conditions that he appear as ordered, keep his contact information current, not to leave the state without permission, to commit no new crimes, no contact with Cordell Berge, not to purchase or possess any firearms or weapons, no threatening, intimidating, and harassing behavior, GPS tether, house arrest under conditions set by community corrections.
Your Honor,
Yes.
if I catch bond, I've already set it up at Harvard Hall. It's supposed to have been there at 9 o'clock this morning, inpatient. I'd like to know, have the written record let you know since November 20, day before I bonded out, I've been clean ever since then. I've been doing my randoms, Your Honor. I need help. I am powerless. I need to go to rehab. I've never asked on my own. I've always been told by the judge, you need it. I felt if I asked for it, like I did in front of you before, and you let me get it, and maybe I could get something out of it. I'm tired. I'm powerless, Your Honor. I'm so powerless.
Mr. Haynes, I agreed that you needed treatment. That's why I allowed you to go, but instead you somehow get stopped and you're found to be in possession of a firearm. So you're now going to sit in jail until these cases are
Can I
resolved.
still go?
No, you are on GPS house arrest tether if you bond out in the new case.
So if I bond out on a new case, I can't go to rehab.
Correct.
So what kind of help can I get, Your Honor? I'm bipolar, I'm on disability. I need.
Mr. Haynes, we'll have to wait. We'll have to wait till we get to sentencing. And it's at this point, I'm going to stop that conversation because your attorney is not present in those cases. And I don't want to have any ex parte communication with you about those cases. All right. Next arraignment.
Let's pause right here, because what we just watched are two very different defendants, but the same brutal reality of the criminal justice system when violence is involved. Starting with the first case, Eric St. Onge, on paper, this looks like a routine arraignment. The judge is calm, the defendant is polite, everything feels procedural, but then the prosecutor drops the real bomb. The victim was allegedly slammed into a wall, thrown around the room, and choked. And not just claimed, the court reviewed photos showing bruising and marks around her neck. That's not just domestic violence. In Michigan, strangulation alone can elevate a case into a serious felony, because it's one of the strongest predictors of future lethal violence. That's why this charge carries up to 10 years in prison. And here's what's really chilling. The victim didn't even want a no-contact order. That's actually very common in domestic cases. Victims often minimize, protect, or feel emotionally tied to the person who hurt them, but the judge didn't care about feelings, he cared about risk. So even against the victim's wishes, he imposed a full no-contact order, weapons ban, alcohol ban, and a $5,000 cash surety bond. Translation: the court looked at Eric and said, "You might be calm right now, but based on what's alleged, you're a real threat." Now compare that to the second case, Michael Haynes. And this one is on an entirely different level of chaos. This man doesn't just have a record, he has a criminal history longer than most court transcripts: home invasion, domestic violence, felonious assault, meth use, weapons charges, probation, multiple open cases, bond violations. This isn't someone who made a mistake. This is someone who has been cycling through the system for over 2 decades, and the timing makes it even worse. He tells the judge he was literally on his way to rehab. He says he's clean. He says he's trying to change. But then the prosecutor reveals that during a traffic stop, a handgun was found in his possession. Let that sink in. He's a convicted felon. He's already on bond in 2 other weapon-related cases. One of his bond conditions was no weapons. Another was no threatening behavior. And now he's allegedly pointing a gun from a vehicle. From the court's perspective, that's not relapse. That's total disregard for the law. And this is where you see the shift. The judge stops negotiating, stops entertaining treatment, stops listening to emotional explanations, and instead labels him exactly what the system sees him as: a threat to the community. Then comes the nuclear moment: $500,000 cash surety bond. Not 10%, not personal recognizance, not even something realistic: $500,000 in cash. That's the court effectively saying, you're not getting out unless someone posts a fortune. And even then, you're on GP's house arrest. And the most tragic part, Michael breaks down. He calls himself powerless, says he's bipolar, says he needs help. But at this stage, the system isn't built for sympathy. It's built for containment. Once you reach this level of repeat violent behavior, the court's priority is no longer rehabilitation, it's public safety. So here's the real question for you watching. If you were the judge, would you have done anything differently? Should Eric have been given a chance to go home despite choking allegations? Should Michael have been sent straight to rehab instead of facing $500,000 bond? Or does there come a point where the system has to stop giving chances and start drawing hard lines? Because what these 2 cases show is the full spectrum of criminal court: one defendant at the beginning of the fall, another already at the bottom with nowhere left to go but prison. And that's what makes courtroom footage so powerful. You're not watching entertainment. You're watching people's entire futures being decided in real time. In both of these cases, the judge made it clear that violence, especially involving domestic abuse or firearms, triggers the most serious responses the court can give. Eric St. Ange walked out with strict conditions and a felony hanging over his head. Michael Haynes walked out facing a $500,000 bond and the real possibility of spending the rest of his life behind bars. These decisions reflect how the justice system prioritizes public safety over second chances when patterns of dangerous behavior emerge. And now I want to hear from you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, because the next case gets even crazier.